Our topic in this episode are the limitations on the law-making power of Congress. I have mentioned earlier about Congress as the law-making body of our government. The Congress, which is referred also as the legislative branch of the government, is composed of two houses. First is the House of Representatives or the lower house, and second is the House of Senate or the upper house. The Congress exercises legislative power, which is referred to as the power to enact, amend, or repeal national laws to include criminal laws. The basis of the government of its lawmaking power is the so-called police power. Police power is the power vested in the legislature by the Constitution to make, ordain, and establish all manner of the wholesome and reasonable laws for the good and welfare of the state and its people. Nothing grants a government this police power, but it is inherent upon every government duly established, together with the power of taxation and the power of eminent domain. In the exercise of lawmaking power, does it mean that the Congress can enact any law? The answer is no. The 1987 Philippine Constitution provides the limitations on the lawmaking power of Congress, and they are the following. 1. The Congress cannot pass an ex post facto law. 2. The Congress cannot pass a bill of attainder. And 3. The Congress cannot pass a law that inflicts a cruel and unusual punishment or impose excessive fines. An ex post facto law is a law that would make a previous act criminal, although it was not so at the time it was committed. An ex post facto criminal law is not allowed because it violates the principle of prospectivity of our criminal laws, which is founded under Article 366 of the Revised Penal Code. A bill of attainder is a legislative act that inflicts punishment without trial, its essence being the substitution of legislative order for a judicial determination of guilt. A bill of attainder is not allowed because it violates the time-honored principle of due process of law, which is followed in our jurisdiction. Accordingly, due process of law is one which hears before it condemns, or one that conducts trial before judgment. This could mean that in violation of a criminal law, a court trial must first be conducted against the suspect, and a penalty can be imposed only after trial if the suspect was found guilty of committing a crime. On the other hand, the courts and not the Congress were empowered by our Constitution and by our laws to impose penalty against those they found guilty of committing a crime. Lastly, the Congress cannot pass a law that inflicts cruel and unusual punishment or impose excessive fines. Cruel and unusual punishments are those that are either barbaric or very severe for the crime committed. Examples are torture, beheading, stoning, and whipping. On the other hand, a fine is said to be excessive if it is obviously heavier with the gravity of the offense it intended to punish. Example of excessive penalty is death for the crime of theft, where the amount of the stolen property is only 5 pesos. So those are the limitations on the law-making power of Congress.